appellants. I'm Matthew Evans of the Knoxville Bar with Kay Griffin. Thank you, Your Honor.
Thank you. You may be seated.
May it please the court. Good morning, Your Honors. As you said, my name is Jonathan Tofflon. I'm representing the subrogated insurance carrier plaintiffs today, the insurers of property damaged by wildfire. This case involves hundreds of properties and tens of millions of dollars of damage. Specifically, this case involves 3 trees which fell on top of power lines, igniting 2 wildfires in Sevier County. We refer to them as the Little Cove wildfire and the Copley Knob wildfire. That these trees were hazardous at the time of Wolf Tree's work, the defendant in this case, is not contested. And what I mean by hazardous is posed an unreasonable risk to the power lines and posed an unreasonable risk of failure. 2 separate ideas in the ANSI standards. Further, it's not contested in this case that the hazards were obvious to someone standing within the right-of-way. Looking at the tree line, these hazards would have been obvious to someone standing there, not someone out in the forest, but someone standing there. And I say that that is uncontested because the only evidence in the record is from Michael Mahoney and Michael Neal, the affidavits regarding how obvious these hazards would have been at the time Wolf Tree did its work. It's also not contested that had Wolf Tree detected the hazard trees, these trees would not have fallen on the power lines, and these wildfires would not have occurred.
Counsel, I'm sorry to interrupt you so early in your argument, but we're talking about things that are uncontested. Is it also uncontested that these damaged trees were outside of the scope of the contract work that was agreed upon?
No, Your Honor, not at all. The plaintiffs and appellants would argue that they were within the scope of the contract. That's one of the contentions of error in the trial court. Even that these trees were not in the right-of-way, particularly in the Little Cove matter. There's 2 hazard trees involved. Both trees fell on the power line. One of those trees, according to the affidavit of Michael Mahoney, the canopy of that tree was extending into the right-of-way corridor. So the distinction here is that the trunk of the tree was outside the right-of-way, but the canopy itself was inside.
Does the contract delineate between whether it's the canopy or the trunk that is supposed to be considered when determining whether it falls within the scope of the contract?
No, Your Honor, not at all. And what the basic position of the plaintiffs, Your Honor, is that the right-of-way was a minimum trimming requirement. It established the minimum. So in the Little Cove case, that involves transmission lines. There, the right-of-way was 25 feet. Trimming to 25 feet was only a minimum under the contract.
So where is the maximum? Is it unlimited?
The maximum is something determined by the vegetation manager, Your Honor. According to the standards, a vegetation manager, and the standards that apply to a vegetation manager are ANSI Part 7. So the vegetation manager evaluates the site, defines action thresholds, evaluates and selects control methods, and implements those control methods. So how far they go out depends on what they see. Whether or not they see an obvious hazard that needs to be removed, whether or not they see that pruning a tree at a particular point might be detrimental to the health of the tree, that all is determined by the vegetation manager, according to the plaintiffs, Your Honor. No.
Did the contract address who had responsibility for gaining permission to remove trees which were outside the right-of-way?
For gaining permission, yes, it did, Your Honor. The contract had 2 appendices. They were labeled minimum requirements. And they said that the vegetation manager had to essentially gain approval of the Sevier County electric system to remove a tree. The reason for this approval was that the bid for tree removals, regardless of where they were, was priced per tree. When they were setting up the contracts, they didn't know how many trees they were going to remove because they hadn't looked, they hadn't performed any inspection. So they had to do it per tree. When they got out there, they identified the trees that were to be removed, and because there isn't, there shouldn't be an unlimited. Because of SEES's limitations, they said, we will pay you per tree, however, you need to get approval from us.
You referenced that you're referring to the contractor or the utility company.
The contractor must get approval from the utility company under the ANSI standards and under the SEES requirements and standards.
And by contract, you have that responsibility.
Yes, Your Honor. Yes. And that responsibility was only to gain approval to remove the tree. I think the primary question is that utilities in the state of Tennessee, Sevier County Electric System, they have a duty to manage vegetation around power lines so as not to allow it to become a hazard to their power lines. Both trial courts affirm this duty of the utility. It's explicitly in the case law cited by plaintiffs. One of the clearest cases is Rogers v. Chattanooga, talking about the duty to patrol and inspect. And it's been enacted by the legislature of the state of Tennessee by their adoption of the National Electric Safety Code. And specifically, Section 218 establishes that vegetation management must occur around power lines and power equipment, and that vegetation cannot be allowed to become a hazard. The question presented.
Definition as to what is considered around the power line and the power equipment as to how far that obligation or duty pertains to?
The National Electric Safety Code does not establish a clear line as to exactly what must be done, and that is in accord with all the standards. What must be done, I mean, trees are living things, and what must be done depends on what the vegetation manager determines. This is a lot of expertise required. Which way is this tree leaning? How thick is it? What is the structure of this tree? Are there codominant stems like there was in one of these, two of these trees, both vying for, power? Is there visible decaying and rotting? There are many, many different factors, and those are laid out in the ANSI documents, but you can't know exactly how to protect the power line unless you're there standing there. And that vegetation management is what was being contracted for. This is a contract for tree trimming and vegetation management within proximity of SEES's power lines. That's what the two-page contract states. And then the SE requirements and standards lay out minimums. They do not lay out maximums. Nowhere is it said how far they must go in order to remediate hazards. Now, on that point, the ANSI standards establish a minimum level of inspection. There is no industry standard that is under this. We're referring to it as level 1, but all it means is that you're standing in the right-of-way and you're observing for obvious hazards. That's it. It is not crossing the right-of-way, going out hundreds of feet, circling trees. That would be level 2, only merited if you saw an obvious hazard. So the vegetation manager is proceeding down every step of these circuits, and they're looking for hazards. They're looking to trim back to the right-of-way, number 1. Number 2, they're looking for any hazards, however those hazards might be remediated, whether it involved pruning or removal of the tree. And that could only be determined by inspecting. One of the first points of error I wanted to touch on was the NESC, and specifically its applicability to contractors hired by the utility system. A full version of the NASC was included in the record, although not cited in our brief. I apologize for that. It's at volume 5, page 680 specifically. And in the introduction and subsection 12, general rules, subsection B, it states very explicitly that authorized contractors shall be responsible for meeting applicable requirements. There was some text omitted, but I just wanted to point that out. Excuse me. In addition, at multiple places in the contract, Sevier County was required to comply with Treeline USA guidelines. Treeline USA is a voluntary association. It's actually an award if you are a member of this. And Treeline required compliance with ANSI standards, also required compliance with state and local statutes and ordinances. And under the contract, Wolf Tree agreed to meet Sevier County's requirements under Treeline USA. So they assumed the duty, or assumed contractually SEES's duty to comply with state law, but we would say even more than that. Someone who is performing vegetation around power lines has a duty to comply with state law just by virtue of them performing the task that is regulated by the legislature. If I can move then to the assumption of duty. I'm sorry. We think maybe the most important error of the trial court was that their opinion does not reflect what actually happened on the Weirs Valley and Jones Cove circuits. The trial court's analysis mentions the Four Corners rule, and we did not plead a breach of contract. This is a tort duty, and we would ask this panel to affirm that the tort duties are based in the facts, not the facts in the contract, the facts of what actually occurred, and the facts establish, we believe unequivocally, that every inspection of every tree, and there was over 2,700 hazard trees which were removed, the vast majority of which were removed from outside the right-of-way. Wolf Tree was involved in every inspection. There was only two ways that inspections occurred on either of these circuits, according to the testimony. A Sevier County electrical supervisor would get in a car with Wolf Tree, and they would ride ahead of the crews, and they would observe, and driving in a car down the right-of-way is specifically approved by the ANSI standards, specifically the best management practices for Part 7, Integrated Vegetation Management. And looking outside the car, they would observe for physical or obvious hazards. Depending on which, go ahead.
Do you have a history, was there presented a history where Wolf Tree, who the vegetation manager, would actually has in the past gone outside of the right-of-way to cut trees
Yes, Your Honor, and according to the testimony of Daniel Allen, Daniel Allen provided pivotal, crucial testimony in this case. Daniel Allen was the only supervisor, or from the depositions, Daniel Allen is the supervisor for both the Weirs Valley and the Jones Cove circuits for Wolf Tree. And what he stated was, he was asked, how about if there was, or let me quote this, how about if there were a tree that could have, if it fell, could have hit the lines, but was off right away? Did you look at those? Objection of form. Answer, if it was noticeable. That was Wolf Tree's answer. If it was noticeable, that's what they were looking for. Again, did you ever mark a tree for removal that was off the right-of-way? Objection of form. I have. So, and then question, so when you made those marks, was that something you did with Mr. Underwood or Mr. Dunn being present? Those were the SEES supervisors. Or was that something you did by yourself? Objection to form. He answered, I've been by myself. So this is the testimony of Wolf Tree saying that he was looking for noticeable hazards beyond the right-of-way, and that he was marking trees by himself. And this is in full accord with the testimony of Nathan Dunn and Jared Underwood. Nathan Dunn was on the Jones Cove circuit. He said he didn't have any experience inspecting vegetation before the year that these these inspections occurred, 2015. He discussed every tree removal with Wolf Tree because they had the experience, according to his testimony. He testified that he relied on the advice that Wolf Tree would give him as to whether or not a tree should be removed. And again, there is no testimony regarding where, from Sevier County or Wolf Tree, they would not state on the record where the trees were that they were removed. The only evidence in the record stating where these trees would have been is, according to Michael Neal, a vegetation management expert, the affidavit he submitted stating that the vast majority of these trees would have been outside the right-of-way based on the 3-year trimming cycle.
I know we're out of time, but let me ask you one quick question. It's my understanding that the duties of Wolf were different depending on whether they were identifying a hazardous tree or whether they were just pruning. And so, as I understand, you correct me if I'm wrong, but if the tree was hazardous and outside of the right-of-way, that was a different obligation than it was to actually prune the trees that were inside of the right-of-way. Am I correct on that?
We believe it was the same, it would be the same inspection and the same obligation. The choice that's being made by the vegetation manager is the exact control method, according to the language. What needs to be done to remediate the hazard? Can it be solved simply by pruning, or does the entire tree need to be removed? That depends on what the inspector sees first.
And if the entire tree needed to be removed, was not that duty limited to the whatever it was, 25 feet on each side of the right-of-way, or within the right-of-way?
No, Your Honor. We would say in the appendix, it states that all of these trees they're described as tall, dead, dying trees, tall enough to hit the utility lines, shall be removed, and that's that section is labeled minimum requirements.
Thank you.
Thank you.
For the appellees.
Good morning, Your Honors. I'm Jessie Zeigler with the Nashville Bar. I am counsel for Defendant Wolf Tree in this matter. And summary judgment was properly granted to Wolf Tree in both of these cases because Wolf Tree did not have any duty to go outside of the right-of-way and inspect for hazard trees. As we say in the brief and an argument, and as both of the trial judges found, there's the obligation, the duty considers an analysis of the contract, common law, and statute. And in neither of those, any of those, is there a duty that imposed upon Wolf Tree, the contractor for SES, to go outside of the right-of-way. And I don't know if you have I was looking for the record, and it says the oversight was held at court, so hopefully you have access to the diagrams that are in the affidavits of Mr. Lynch, who was the surveyor, because they will help you visualize where these trees were and how far outside the right-of-way in a heavily forested area they are.
We have access to everything that's in the record.
Okay, so those are Exhibit B and C to Ryan Lynch's affidavit in both of those cases, so you can see a visual. The other thing that's important from the record, in our view, that I think would help guide the court is the booklet that we put together that's Exhibit 1 to the hearing transcripts for both of those, and that's at Record 2289 in the Cobley Knob case and 2395 in the Little Cove case. And the booklet contains the SES standards and the contract and the NESC. And so you can more easily see what actually was required of Wolf Tree. So the contract, which is in tab 1, tells you that it's a contract for tree trimming and other vegetation management within these circuits, and that they were to perform tree and other vegetation trimming within proximity of SES power lines and other equipment per provided specifications, requirements, and mandates, and according to the SES standards. And when you go to the SES standards, and what you won't find, Your Honors, anywhere in the contract or in the SES standards is an obligation for Wolf Tree to go out and conduct hazard tree inspections. You're never going to find the word inspect or inspections in there because this was a tree trimming contract for the right-of-way. And I heard counsel discuss, well, you know, they didn't prune within the standard of care, and there was a canopy that was overlaying into the right-of-way for one of the trees in the Little Cove case. But that, Your Honor, is irrelevant, because they said it themselves at the oral argument that that was not at issue in this, and that's at page 59 of the transcript of the oral argument. This is not a standard of care about the pruning. This is whether or not these two hazardous trees at Little Cove should have been removed, and this one hazardous tree at Cobley Knob should have been removed. I also heard counsel say that there's no dispute that these were hazardous, and I just want to make it clear that's for purposes of summary judgment. We said even if these were hazardous trees, then under the negligence standard, duty is a question of law for this court. And there was no duty by contract, by statute, or by common law for Wolf Tree to go outside of the right-of-way into these heavily forested areas and examine trees for removal. Nor did they do that, in fact. So I heard counsel talk about the testimony in the case, and you know, I submit it's a complete mischaracterization of the actual testimony. There is not one witness that said it was Wolf's duty to go outside the right-of-way to do these inspections. Every single witness for SCES and for Wolf said that was not required by the contract. So, for instance, Steve Springer, Steve Springer, which is not cited in their briefs, but pages 9 and 10 of his deposition, which is in the record, he serves as supervisor of vegetation management for SES, and he has since 2009. He testified that he created the SES standards, and his testimony, he was asked, but whose obligation under the contract was it to specify if a tree needed to be removed? He said, I'm sorry, anything outside of the right-of-way would be ours. Question meaning, answer, because it is our call. Meaning SES's, yes. And then he was asked, just to clarify, the work that Wolf Tree did on the Wares Valley Circuit was completed on time and to SES's satisfaction? It was, yes. How about Jones Cove? Yes, it was. Were there any trees that SES specified should be removed in 2015 on either the Jones Cove Circuit or the Wares Valley Circuit that Wolf Tree failed to remove? There were none. Daniel Allen, who was Wolf Tree's supervisor for both circuits, says he does not remember in either circuit whether he made a recommendation to SES to remove a tree outside the right-of-way.
Is there evidence that there were certain trees which were removed, which were outside the right-of-way?
Yes, there are trees that are removed outside of the right-of-way.
Does that bear on the issue of that?
It does not, Your Honor, because SES, the contract had a price, and it says that outside, and the standards say that anything outside of the right-of-way can only be removed at SES's direction. So if you look at the SES standards, that's what it says. Nowhere does it require Wolf Tree to go find those trees. But if SES says, we need you to go remove this tree, you go remove it.
So the evidence is that all trees outside of the right-of-way which were removed only upon the approval of the utility system.
Yes, and the corporate representative, Mr. Hedrick, who said that 100% of the time that was true. Every tree that was removed was approved of by SES.
As I understand it, the reasoning for that is because the contract was that trees removed outside of the right-of-way were priced per tree. So and I'm trying to conceptually understand this world, which is foreign to me, but, so otherwise, if they just go and willy-nilly choose which trees they want to remove, they could ostensibly inflate the price. I mean, they could make more money for themselves. Is that why it required the utilities permission to make sure that the price, it was not just, we're going to just take out whatever tree we want and charge you for it?
Yes, that's a big part of the reason, Your Honor, that it's very expensive to remove a tree. If you've ever had one removed from your yard, you know. So it was SES's obligation also because it would have been a much more expensive contract to do an inspection contract, just to go out. If you had to go out, hire these contractors to go outside of your right-of-way. And for Little Cove, the transmission line, it was 25 feet on each side of the right-of-way. The distribution line at Cobbly Knob was 10 feet on each side. If SES has to pay its contractors to go outside of the right-of-way, then they have to pay for that service, and that's expensive. As you know, Sevierville is very much heavily forested. So if you're paying contractors to go outside, that's a totally different scope of work. And the California case that the plaintiffs like to cite was an inspection contract. And I read their reply brief where they said it's not. I invite you to read the case yourself and make your own decision. But the court ruled that there was an inspection. That's California law, which is different from Tennessee law as well. There's a statute you can also read that's totally different from Tennessee law. There isn't an obligation under Tennessee statute for a contractor to go outside of a right-of-way to trim the circuit. So there's nothing under
Is there an obligation for a contractor to warn the utility that could be a problem with a certain tree that they've noticed or something of that nature?
When that's a standard of care issue in terms of when you're doing your work within the circuit, and the testimony is that if Wolf Tree saw something, they would bring it to SES's attention. That didn't mean they assumed the duty to go outside the right-of-way and do the inspections, which is an entirely different issue than if you're working in the right-of-way and you see a tree the SES didn't tell you about that you want to bring to their attention and ask whether they want it removed. You don't want to disincentivize the contractors from bringing those trees to the utility's attention. You want them to do that, but that does not mean that they assume the obligation to go inspect all of the trees outside of the right-of-way to determine whether or not there's any hazard trees out there. You will not see that in the contract. You will not see that in the specifications. The ANSI standards is such a distraction because the only thing that the standards requires compliance with the ANSI standards for is the pruning, how the pruning is done, because this is a tree trimming contract. And so that's what it says when it references the ANSI standard. It says the tree pruning shall be done in accordance with these things, and one of them is ANSI. So it's how they go about doing their pruning that they're complying. It doesn't mean that all of the ANSI standards suddenly govern what they have to do for SES. SES decided what Wolf Tree needed to do for it, and the testimony is consistent across the board that it was SES's obligation, and that SES wrote ahead. It wasn't the testimony that SES wrote with Wolf Tree. I invite you to read the testimony. SES wrote ahead or tried to write ahead and mark the trees ahead. They tried to stay ahead of the contractor to do that. The consistent testimony across the board was that that was SES's responsibility. And so if there's no duty under the contract, which there is not, and also depositions were taken in this case. We opposed that. We didn't think it was necessary. We had already filed a summary judgment motion when they requested to take depositions. We don't think the deposition testimony is even necessary because the contract is clear, and under the individual health specialist case, extrinsic evidence need not be considered when the contract is clear. But we're not afraid of you considering it either. There's the deposition testimony, which is all consistent, that the contract is a tree trimming contract for the right-of-way, which is what was done. And if SES directs that a tree should be removed, or approves of a tree being removed, then the tree gets removed, and it gets paid for by that. Under the statute, the NESC, all of that says is that it's not practical to prevent all tree, it says that it's not practical to prevent all tree conductor contracts on overhead lines, and that vegetation management should be performed as experience has shown necessary. It's inviting the utilities to determine themselves what, based on their experience, is necessary for their lines. And as Mr. Springer testified, for SES, he developed those SES standards to determine what made sense for SES when they are hiring these contractors. Wolf Tree is just one of many contractors that they hire. It just so happened that on these 2 circuits, before the fire, Wolf Tree was the last one on these circuits, but at the same time, there's lots of contractors doing the same sort of work under the SES standards, the same sort of contract, same standards on different lines. And they're not inspecting outside of the right-of-way unless they had a different contract with SES where SES asked them to go do that. Under the common law, because the reply brief makes much ado out of this duty and tort, the duty and tort can only come out of the common law. And there is no, this was a nonfeasance case, so we went through the Satterfield analysis in our briefing, and the trial courts did as well. And this is not a case where Wolf Tree affirmatively did something as an allegation that caused a fire. It's an allegation that they failed to act. And there's no special relationship here between Wolf Tree and the plaintiffs or their insureds. And so under that analysis, they had no duty under the common law either. And as for trespass, they allege that it was an intentional trespass, but then they said later that they were claiming negligent trespass. Obviously, there's no intentional trespass because there's no evidence that Wolf Tree intended to have a fire start in either of these areas. And negligent trespass requires the same analysis of duty. And so the trial courts properly dismissed those claims as well. And for nuisance, this is not a nuisance case either because nuisance is different from negligence and it requires an active wrong and some sort of intentional act. And there was no nuisance created by Wolf Tree here, and so those were all properly dismissed as well. I have additional time in which, if it's helpful, I can cite additional testimony that shows you that none of these witnesses said that Wolf Tree had an inspection contract or an obligation to go outside the right-of-way. I have those citations ready, and I can read those to you, or I can answer additional questions.
If there's you present your argument as you see fit. I hear no additional questions, so it's up to you how you proceed.
Okay. Well, then I will refer you to the record and the deposition transcripts, and not the plaintiff's rendition of it in their briefs. I would suggest look at the actual deposition testimony citations because none of the witnesses said that Wolf Tree went out there to do inspections.
Thank you very much.
Thank you.
You have your rebuttal.
Thank you, Your Honors. I wanted to address specifically the pruning and tree trimming contract arguments of Wolf Tree. The plaintiffs in this case would argue that this distinction between pruning, tree trimming, vegetation management, tree removals, this is a distinction without any meaningful difference. It would only change the phrase of the issue, and that would be, did Wolf Tree have a duty to prune these trees in such a way as to remediate the hazard? Under the SCES standards, if they pruned a tree, or if the appropriate control method would have been to prune a tree more than 50%, they had to stop, call SCES, and ask for removal or ask for approval to remove the tree. Pruning requires inspection. Under ANSI A300 Part 1, it says an arborist or arborist trainee shall visually inspect each tree before beginning work. You have to inspect in order to prune. Whether or not you end up pruning or removing a tree is up to the vegetation management professional, and they must determine what control method is appropriate. According to ANSI A300 Part 7, distinguishing between whether a tree should be pruned or simply removed is a distinction which must be made by the vegetation manager, and it refers the vegetation manager to Part 9. And Part 9 is completely agnostic as far as whether or not a tree removal is the appropriate remediation method or pruning. So all of these parts involve pruning. If pruning is appropriate, pruning should be done generally. If removal is the only thing that can remediate the hazard, the entire tree must be removed.
And in this case, if Wolf determined that the tree needed to be pruned, they would prune it. But if, and I'm not going to make the distinction between within or without the right-of-way, but if they determined that a tree needed to be removed, they could not do that without SEES approval, correct?
Yes, Your Honor. And
Okay.
the testimony establishes that they would normally call, do it verbally, send a picture to the Sevier County electrical supervisors, or they would be with the supervisors when those trees were identified. And I also want to mention Dr. Shigo's. This didn't make it into the brief. Dr. Shigo's pruning guide, one of the 3 documents in the opening paragraphs, paragraph 1.2 of the requirements and standards mentions Dr. Shigo. This is a pruning guide. And in there, it directs the vegetation manager to, and I quote on page 30 of this guide, remove large branches and trees that are obviously dangerous. Be on the alert for dangerous trees after storms. These 2 ideas are one and the same. You have to inspect if you're pruning, and whether or not you have to remove or prune, that is up to the vegetation manager. That's what they're doing. That's why this guide is only stating minimum standards. It's only stating the different acceptable control methods, and it's up to the vegetation manager to determine which one applies in every situation. I also wanted to mention that Wolf Tree has stated multiple times that trees were only supposed to be removed at the direction of SEES. That word direction is not in any of the standards or the contract. What the appendix states is that if in SEES's opinion, so they have to present this to SES and SES must determine if they have approval. Again, this often happened without them even seeing the tree, just over the telephone. Also, Counsel for Wolf Tree has mentioned a lot of testimony from Steve Springer. I just wanted to point out that Steve Springer is the one who authored these. He was asked point blank, or he authored the requirements and standards. He said, the question was, I just wanted to clarify under the contract that Wolf Tree had with SES in 2015, the contracts for Wares Valley and Jones Cove, quote, was it SES's duty to identify any trees that needed to be removed outside the right-of-way? Was it our duty? Yes. And then answer, the electric system duty. It would be kind of working in hand, the best way to answer that question. That's specifically asking whose duty was it to identify these trees. SES and Wolf Tree supervisor would ride ahead, or Wolf Tree would be calling SES when they were on other circuits. Okay. The panel didn't have any other questions. Thank you, Your Honor.
I hear none. I want to thank the attorneys for your presentation. Your case has now been submitted to the Tennessee Court of Appeals. You should receive our opinion within a reasonable period of time. Thank you again. Attorneys may be excused afterward.